Welcome to the 2020 Virtual Spring Meeting, brought to you as a special edition of Our Curious Amalgam, the American Bar Association Antitrust Law Section's podcast. Virtual Springs Eternal, Friday, April 17th through Friday, May 1st, as we bring to you some of the top programs from the now canceled in-person spring meeting, as well as new hot off the press programs discussing the most compelling issues of the day. Be well and enjoy the show.
Hello and welcome to the Virtual Spring Meeting. My name is John Roberti. Today, we are delighted to present a really great panel, Merger Analysis Gone Digital, Time to Reboot. The panel is sponsored by the Mergers and Acquisitions Committee. And with me now to provide some context are Mike Keeley and Joanna Tsai, the co-chairs of the Mergers and Acquisitions Committee. Mike is a partner and the co-chair of the antitrust practice at Axum, Veltrop, and Harkrider. Joanna is vice president in the antitrust and competition economics practice of Charles River Associates. Hi, Mike.
Hey, John.
Hi, Joanna.
Hi, John.
Mike, let's start with you. What is today's panel about?
Well, it's going to be a great panel, I think, John, and it's around the technology sector and what I hope to be a really enlightening discussion about how enforcers and counsel and all of us in the competition world are going to navigate our way through calls for more active merger enforcement in the tech sector. Is it necessary? Is it a good idea? Is it a bad idea? How to go about it? And I'm really psyched.
Joanna, let's go back to you. Why is this important?
Well, John, technology has become increasingly important in our economy and our lives. Merger enforcement needs to be powerful enough to block anti-competitive mergers without losing the ability to allow pro-competitive ones to go forward. Finally, merger analysis is inherently forward-looking. Some characteristics of the tech economy makes predicting the future harder. For example, nascent competitors, non-price factors, the effect on innovation.
And Joanna, what are we hoping to get out of the panel today?
First of all, I think that it would be very helpful to define and understand the key economic characteristics of tech firms. You know, what are we talking about when we speak about the merger enforcement of, digital platforms and digital economy? Secondly, large firms' acquisition of nascent competitor and potential competition cases, how do we evaluate them and what are the important factors to examine? And then finally, we hope to hear about, whether new tools, laws, or guidelines are necessary.
Mike, Joanna, great commentary. I'm hoping maybe you will stick around and listen to the panel with us, and then we can talk afterwards about some of your takeaways. Is that okay?
Thanks, John. Sure, we'll stick around.
Sounds great.
All right. Well, in that case, let's send it over to Haidee SCHWARTZ, the moderator of the panel, and get things started. Haidee, take it away.
Thank you, John, for the introduction. I'm going to start with a brief overview of the bios of our panelists today and speakers. First, there is Commissioner Christine Wilson. She was sworn in September of 2018 as a commissioner of the FTC. Commissioner Wilson previously served at the FTC as Chairman Tim Morris's chief of staff. Wilson has practiced competition and consumer protection law at law firms and as in-house counsel, including as senior vice president for Delta Airlines, and before that as a partner in private practice. Carl Shapiro is a senior consultant to Charles River Associates and the Transamerica Professor of Business Strategy in the Haas School of Business at the University of California at Berkeley. Shapiro served as a member of the President's Council of Economic Advisors during 2011 to 2012. Dr. Shapiro also, 2 years immediately prior to that, was Deputy Assistant Attorney General for Economics at the Antitrust Division of the U.S. Department of Justice. But he also previously held that position. Diana Moss became president of the American Antitrust Institute in January 2015. An economist, Dr. Moss's work spans both antitrust and regulation. She has spoken widely on various topics, including competition and enforcement, testified before Congress, appeared before state and federal regulatory commissions, and has made many radio and television appearances, as well as publishing numerous articles in economic and legal journals. Foad HOSEINIAN is a European counsel in the Brussels office of Sullivan and Cromwell, advising clients on global merger and antitrust investigations. Prior to rejoining private practice in 2012, Foad clerked with Judge Niles Wall at the General Court for the EU for 6 years. Now, right into our program. The panel's title is Mergers Analysis Gone Digital Again, Time to Reboot. And we're going to start with the current tech economy. Carl, or Dr. Shapiro, from an antitrust perspective, what are the key characteristics of today's technology economy, and how did we get to the current tech economy we have today?
Thank you very much. Well, let's first define maybe what we mean by tech economy. Probably different people mean different things. 100 years ago, I don't know that we would have talked about an electricity economy as electricity was starting to, roll out in its impact, or an automobile economy, although those things were fundamental. I think maybe for today, I'm going to use the term at least, and we're thinking about mergers in which industries or which sectors. It's really, I'm thinking about information and communication technology sectors, which would include media, social media, parts of advertising, hardware, software, computers, telecom. Okay, so quite a bit. This isn't just the big tech firms we hear about, Google, Apple, Facebook, and Amazon, but includes Verizon, Qualcomm, Disney, Netflix, and so forth. The key economic characteristics, as always with antitrust, you want to start with thinking about what are the sources of economies of scale. What are the advantages that big firms have, which is why we see large firms and we see concentrated markets, and that's usually what's bringing in antitrust, certainly on the merger side. So the sources of economy of scale, for one thing, we have, these are innovative industries, so there's a lot of R&D. And R&D is generally a fixed cost. You spend money, develop a new product, and then that cost needs to be amortized over as many units as you can sell. So the more there's R&D, you have fundamental source of scale economy. In other areas, we have, it varies. If you're Comcast, you've got to lay down the wires, right? So that's always been a scale economy in telecom of building out networks. In software and content, you have what are called first copy costs. So you have to spend money to produce a piece of content or software, and then the very low marginal cost to distribute it. That's another source of economy of scale. Probably the economy of scale we hear about a lot now are network effects. So the fact that when you're in a network and you're communicating with other people, this could be a social network. It could be a platform, that has software and users or apps. We have what are sometimes called demand side economies of scale or network effects. So those could be very, very powerful. So those are the sources of economy of scale that are driving things. We also have economies of scope. Okay, which is basically the efficiencies of offering multiple products within the same firm. And, this comes from a number of sources, but it relates to something that's gotten a lot of attention lately, big data. When a company accumulates a lot of data or acquires it, that data can be used for many purposes, right? Google spent a lot of money to develop Google Maps. They don't make money directly with consumers from Google Maps, but think of all the things they do with that in terms of locational services, advertising, and all sorts of other things they can do to track people and to take advantage of locational information that earns them revenue. Okay, and at the same time, they've got expertise in using data for whether it's Google Home or improving their search or YouTube. Okay, so there's economies of scope, and then the last source of economies of scale that I identify, I already mentioned it. This notion of platforms or complements. That products that need to be used together to create value. The classic example would be, let's say, Apple. They have all sorts of users, and they have developers. So you've got, and this is also, you hear the term multi-sided markets. And this means when we talk about mergers, they're often going to have vertical or can have vertical and horizontal elements combined. So all of these features, economic features, are creating the tech economy we see now, and are making and are directly relevant for merger analysis.
Great. And now let's move to sort of what we've seen in recent years. The U.S. antitrust agencies, and in some cases, the UK Competition Authority, have brought or were about to bring nascent competition cases. This includes the FTC's challenge to CDK Automate involving dealer management software for new car dealerships, Illumina Pac Biosciences involving DNA sequencing technology, and even Edgewell Harry's, as well as the DOJ case involving Sabre Fairlogic. In each of these cases, the agencies have argued that the merging companies were in the same market. Should we expect to see more of these cases, and should and how might the antitrust agencies extend their challenges to mergers among companies that are not in the same product market? Commissioner Wilson, could you share some thoughts?
Sure. So I'd like to begin with the statute that we're enforcing when we are reviewing mergers. So in any merger challenge, the Clayton Act requires that the agencies identify the line of commerce where competition will be harmed. The agencies can't challenge mergers between companies that aren't in the same market without showing a market where there likely will be anti-competitive effects. So the framing of the Clayton Act itself makes market definition important. And how a market is defined has important ramifications, as all antitrust practitioners know. Particularly when we're dealing with a nascent competitor or a potential entrant, this market definition issue becomes particularly important. On the one hand, if a market is defined broadly, then the market likely includes many other players, and that makes a challenge difficult. On the other hand, if the market is defined narrowly, then one of the merging parties may fall outside the boundaries as defined, which necessitates a challenge based on a theory of potential competition. And as we saw from the Commission's failed challenge in synergy, there can be significant challenges when a potential competition case is litigated. So these are some of the issues that the Commission grappled with when we analyzed Harry's Edgewell and Illumina PacBio, which you mentioned, Haidee, and we may touch more on those cases later. You also asked whether more potential competition cases should be expected. Former Bureau Director Bruce Hoffman of the FTC spoke before a Senate Judiciary Committee hearing in 2019, and his testimony laid out numerous challenges based on potential competition theories and acquisitions of nascent competitors over the years. And so his testimony in and of itself demonstrates that challenges of this sort are not new and in fact are not unusual. Haidee, you mentioned other cases like CDK Automate, Verisk Analytics, and EagleView. These are also great examples of acquisitions of nascent competitors or potential competition cases where the FTC brought suit. And Bruce's testimony contains many more of these examples. And so I would say in closing, you shouldn't be surprised to see these cases coming out of the FTC now, and you certainly should expect to see more of these cases in the future.
Thank you, Commissioner Wilson. Diana, do you have a perspective and thoughts on this?
Sure, and thank you very much. So I think we're seeing glimmers of hope within the antitrust enforcement infrastructure to sort of tackle some of these more modern and difficult problems. But from our perspective as competition advocates, we see some real disconnects and lag effects in terms of how antitrust is keeping up with changes in business models, different forms of business organization, the role of data, for example, in facilitating connections between markets. So, to sort of dovetail on what Carl said earlier, there's 4 types of mergers. There's not just 3. There's horizontal, there's vertical, there's potential competition mergers, and there's also what I call ecosystem mergers, acquisitions of small edge competitors or nascent rivals, whether they be startups or not. It doesn't matter what the business model is. These acquisitions are brought into a bigger ecosystem of very interconnected, tightly linked markets like we see in digital tech, but also in other sectors like agricultural, biotechnology, and medical supplies and equipment, for example. So what we see based on analysis is the agencies are trying, they're looking. The average rate of second requests is much higher than in other sectors. I'm talking about digital technology specifically, but the rate of challenges is very, very low. So there's really a disproportionality there that is somewhat troubling. So I think antitrust needs to think more broadly, to broaden the lens, to think outside of the traditional horizontal vertical frame of analysis, to think about ecosystems and how additions through acquisitions to those ecosystems can facilitate certain types of conduct. For example, leveraging. If a market participant has a dominant position in something, whether it be search or social media or whatever, how can they structure or strategize an acquisition to leverage market power from one to the other? We have seen DOJ do this once in the Google AdMeld deal, where they did actually look at the possibility of leveraging market power from search into display advertising. But, bottom line, there's a lot of work to do in terms of broadening the lens, getting past sort of the transactional orientation of antitrust analysis that would facilitate looking at these ecosystems of markets. But I also think to accompany that, we need much stronger presumptions, not just in horizontal transactions, but vertical and potential competition transactions.
Thank you, Diana. And we will probably touch on that a little bit later towards the end of the program. Foad, can you give us your perspective?
Sure. Coming to this as a private practitioner from Europe, I think it's fair to say that we here in Europe have already experienced European Commission and the national member states agencies to have focused for a while now on big tech and nascent competition. They have had it on their radar for a while. And to answer your second question, Haidee, I think here we can definitely expect that scrutiny will increase, including in merger control. And just as an anecdotal example, two of the cases you mentioned in the introduction, the Lumia Pacific and the Cyberfile Logic, they're actually publicly, the CMA, the UK Competition Authority, publicly oppose those mergers first. Now that can have to do with the procedure, but again, just as an anecdotal example that Europe is maybe a first mover here. That applies also in terms of studies and how much they look into this. So over the 2 years, there have been numerous reports from European Commission, the UK, France, Germany, authorities where they have looked back at their cases, a track record, and have kind of set out agendas or discussion papers on how they would like to approach tech mergers. And I think what one can say, at least about the European Commission, is that they have realized the issue that Commissioner Wilson mentioned about market definition, that you might not capture these kind of potential foreclosure or competitive harms if you stick to the normal market definition. So European Commission has announced that they will look more and more into what Diana was mentioning as an ecosystem type of competition. And the word they use here in Europe is that they will now look at technology space, or the space where users' attention is competed for. So that's something we can expect that will attract scrutiny and attention. And this is based on when they have reviewed how old cases have been analyzed, and they have noticed that they might have missed an aspect of the analysis. And it's just to sum up, I think this is not something that's surprising for us here in Europe, because looking at this, what they call technology space or users' attention space kind of competition, it's a little bit similar to the approach the European Commission also took a few years ago to the agrochemical cases, where it was one of the first authorities to oppose them. And they did that on the basis of innovation spaces. So they did not look at actual overlaps in terms of pipeline products, which had been the hero harm up till then, but started to look at how much do different companies focus on R&D in particular fields as such. So I think that is to just sum up the status. And just recently we learned that European Commission will also memorialize this approach, most likely in a revised notice of market definition. The old market definition is from 1997, and most likely end of this week they will kick off a consultation process to amend the market definition notice. And one of the aspects they will most likely touch upon is, again, this market definition when it comes to ecosystems.
Great. Thank you, Foad. So when a company is in its early formative stages or is on the cusp of offering a new product or service, how should antitrust enforcers measure the ability of that company to disrupt in the future? In merger investigations, how can antitrust enforcers accurately estimate new and evolving companies' potential trajectory? How much should they need to do so, and where should that burden fall? Carl, can you share some thoughts with us on that?
I'm happy to. Thank you. I think the first point is to recognize that in this situation you've described, an emerging company, there's a lot of uncertainty, inherent uncertainty. The agencies are not going to know what the future is really going to look like. The companies may know better, but they're not going to know either. Okay, so to the extent that we're going to insist on quantifying market shares or measuring diversion between future products, that's going to be very hard and may not really even be where the action is. And I'm very concerned that we're going to have under-enforcement if we insist upon those quantifications as a requirement for the plaintiff, the government typically, to prevail in one of these challenges. So measurement's going to be difficult. I have a paper recently that I wrote with Fiona Scott-Morton at Yale and Giulio Federico at the European Commission called Antitrust and Innovation, Welcoming and Protecting Disruption. And so we go through where you can measure, where you can't, the different fact patterns. Are the companies current competitors? Are they future competitors? Is it more of capabilities out into the future? Different, it's sort of a taxonomy almost of the different cases, but measurement is very difficult. Let me give one example, which we've already heard about, the FTC, the Illumina PacBio, which is in DNA sequencing. The FTC challenged that merger. I served for them as their economic expert. There's a very informative, detailed report by the CMA, and public report that people can look to. And I think it's illuminating because it's a good example of the challenges here to measurement, which you asked about, which is, in this case, Illumina is a leading company in DNA sequencing equipment and systems. And PacBio is up and coming, but had not had great success yet, but very promising technology with a long read, reading longer chunks of the DNA, while as the older technology is a shorter read. So there's a lot of uncertainty about how successful the new product will be. In those cases, I think inevitably, they're going to often be document cases. Like, what do the companies themselves say about their prospects? And when you have, in this case, they're paying $1.2 billion, and there was a lot of concern at Illumina about future competition from PacBio, even though it hadn't played out that much yet in terms of actual success. Those are your markers that you've got a problem. And if there's, say, a failing firm defense because the new firm hasn't made any money yet, that should be greeted with great skepticism. It's more about documents and the best information we have to predict the future, which is hard.
That's great. Thank you, Carl. Commissioner Wilson, do you have some thoughts on this as an enforcer?
Sure. Yes. Thank you, Heidi. So I guess what I would say is that, of course, the problem is not unique to new entrants. You and Carl have described mergers where we are dealing with new entrants like Illumina PacBio, and Carl accurately described the framework that we were analyzing there. But in any merger investigation, the analysis will attempt to determine likely competitive effects. And this is true whether the firms are new entrants or established incumbents. And the agencies use the best available evidence to establish competitive effects, although it may not be perfect. And Carl mentioned disruptors. I would note the horizontal merger guidelines do instruct that the agencies will consider whether an acquired competitor was a maverick or had a history of disrupting the market. And that certainly was a consideration that we had in the Illumina PacBio case. So for new entrants, the agencies try to accurately estimate their potential trajectories. Often, company documents and plans provide a source for those estimates. The documents may be in the hands of a threatened incumbent, or they may reflect the hopes and expectations of the entrant. The participants in a market likely provide the most informed predictions about trajectories for individual firms. But estimating uncertain future effects also occurs when the agencies attempt to evaluate the parties' efficiencies claims. Again, here, the agencies are relying on information from the parties. I've talked about this before publicly. I think the agencies have a sometimes difficult time projecting any competitive effects. I would say, as a matter of course, we have a more difficult time projecting what the benefits are likely to be from a given transaction. And so I would welcome additional input from academia to provide additional ways to estimate future effects with respect to both anticipated harms and anticipated benefits. One note, many believe that antitrust law focuses primarily on static effects like price, output, and quality today, and these metrics certainly are important. But antitrust enforcers also consider dynamic effects in many cases, and occasionally concerns about preserving incentives to innovate even carry the day. So example, dynamic effects and specifically dynamic pro-competitive efficiencies convinced the FTC to clear a 1980-era joint venture agreement between General Motors and Toyota. The divided commission allowed the transaction to proceed with some restrictions, finding that the joint venture would expand output, reduce prices, and allow GM to learn more efficient Japanese manufacturing and management techniques. The commission explained that GM could use what it learned at its other plants to help make its other American-made cars more competitive and spur other U.S. manufacturers to make similar improvements. And so I think it's just very useful to remember when we're talking about the difficulties of looking at the trajectories of where companies may end up, that we should be thinking about this in a symmetrical way. We should be thinking about both the harms and the benefits, and both of those tasks can be equally difficult.
Thank you, Commissioner Wilson. Diana, do you have a few thoughts on this, that in terms of how we should measure and what we should be looking at?
Sure. So let me just add something, some thoughts about the front end of the antitrust enforcement process. And that goes to just getting on the antitrust enforcement radar screen through the HSR reporting process. But before I talk about that, I just want to note that, again, antitrust is playing catch up. We really don't see very little, if any, enforcement in the kinds of spaces that involve acquisitions of potential competitors, smaller nascent rivals who are maybe on the edge of the market or just getting into the market. So antitrust doesn't really have much to look at in terms of merger challenges. We've done empirical work on that, showing, as I mentioned earlier, a very, very low level of merger challenges. But they have been looking in terms of higher levels of second request. So this makes the case for even a stronger case for doing merger retrospectives involving the digital market players, so that antitrust can study and understand what the effects of those types of acquisitions were. But as far as the HSR thresholds go, I think it's really important to realize that if the thresholds are going to use monetary values of revenue streams or values of acquisitions, that's really the wrong metric to be using, because if you're not in the market, you're not generating revenue. So I think in expanding the scope to look at economic resources, for example, control of intellectual property through patents, even the intellectual capital involved in the startup, and the record of those individuals in being successful in previous startups, for example. So I think the lens here has to broaden as well, to make sure that those types of acquisitions are even getting on the radar screen in the first place. And then we can pick up where this conversation, has indicated, once it's on the radar screen in terms of looking at the various metrics and the measurement tools for what constitutes competition and the potential for economic performance. But getting the HSR thresholds right, I think, is a really critical part of this.
Okay, and we may talk about thresholds and sort of guidelines and laws a little bit later. Foad, quickly, do you have thoughts in terms of measurement from a European perspective, and how antitrust enforcers can accurately sort of look at trajectories?
Yeah, very quickly. I think what's important to remember here that in Europe, the European Commission doesn't need to go to court, and no member states even nowadays, to go to court to prohibit a merger. And so the way the system works is a little bit differently in the sense that we have a very long notification process where the parties actually have to educate and explain a lot to the enforcers. So I think maybe it's a little bit easier for the agencies here from the beginning to kind of be able to see the issues, because the parties are on an obligation to really explain things. And up front, the parties here also have to submit a lot of internal documents. So I think what Carl is mentioning, Commissioner Wilson, in the sense that the documents are, of course, very good starting point. But coming back to concrete measurement, I think given that the European Commission is most likely going towards looking at this more from an ecosystem perspective, so not necessarily having to guess whether a nascent startup will be a competitive force in the future, but more looking into, is this acquisition strengthening the ecosystem of the acquirer? Maybe that's going to be an easier theory of harm to bring forward, because you don't need to predict so much how strong of a future competitor this startup might be, but you can only just look at whether it will increase consumer loyalty to the platform.
Great. And another follow-up question to you. In Europe, can abusive dominance cover nascent competition mergers? And is there an advantage in the EC potentially using this article?
Yeah, that's a very good question, because I think by no stretch of imagination can the European Union be accused of being lenient towards tech companies. And you all know the cases, but that's more on conduct. So Google and Intel, of course, have had billion euros fines. Apple has been persecuted for state aid. But most of this Facebook is currently under investigation, and so is Amazon again. But all of those cases has been about conduct. And in merger cases, while the European Commission and national authorities have looked at it, I think to date there is no prohibition decision or a decision where remedies have been imposed. So of course, one is asking itself, should they use Article 102, the abuse of dominance? I think the answer is that is unlikely for two reasons. One is that's a very lengthy process. It's going to take years for the European Commission to come up with a decision under 102. And of course, in mergers, what we need is timely enforcement. And in 102, it's going to be after the facts have happened. Also, 102 has so far been very much based on effect-based, so you have to look at the past, where again here, this is what's important, is to protect the future. So while there are precedents and the European Commission has the power to use Article 102, and the presidents such as Continental Akin or recent Servier, I think it's unlikely that will be an effective tool, except for a situation where we are looking at serial acquisitions. So where you take a bulk of acquisitions a few years from now and look back and say, okay, you made a several number of acquisitions and maybe those combined could be an abuse of dominance. That could be potentially something that's worth pursuing under 102.
Thank you very much, Foad. Moving back to the U.S., when and if at all should a Section 2 count be alleged instead of or in addition to a Section 7 count in a merger challenge? Diana, do you have a few thoughts?
Sure. So this is a tricky, sticky area for antitrust. We have some very good examples of challenges of consummated section merger of Section 7 cases. Versus Section 2 or even versus Section 1, the decision what kind of case to bring, should it be brought in conjunction with other cases, I think is going to require a lot of thought and analysis, particularly moving forward if some of these consummated transactions in digital ecosystem markets are going to be challenged. But clearly, if there is evidence of post-merger harm, higher prices, lower quality, less innovation, then a consummated section merger, Section 7 challenge, is warranted. I think the trick for enforcement is you have to sort of suspend the world, go back to the pre-merger conditions, look at how the merger changed the structure of the market and changed incentives to engage in strategic conduct, and then suspend everything sort of that happened after that, after evidence of harm is apparent. So it's a very sort of constrained framework that enforcers use to look at consummated merger challenges. Section 2, on the other hand, has more flexibility to go back and look at further competitive damage in the market that may have resulted from a merger allowing a firm to leverage a market position beyond what the merger actually got them. So that's an overlay. I think that's subtle in some respects. But Section 2 challenges obviously can look at any changes in the market after the merger, whereas the Section 7 challenge has to sort of stay within that very constrained framework. I also wouldn't take it off the table that using Section 1 is really important. You know, we're not just dealing with dominant firms here in some markets. We're dealing with tight oligopolies as a result of successive serial mergers that have created just a few rivals in these markets. And, you know, I'm always one to say we can't just look at dominant firms. We also have to look at coordinated effects and what's going on in these tightly oligopolized markets. But again, merger retrospectives really, really important for helping guide this particular question.
Thank you very much, Diana. Commissioner Wilson, as someone who actually has to enforce and make these decisions between Section 2 and Section 7, how do you think about this?
So let me just follow up on something that Diana just referenced first, and then I'll get to Section 2. With respect to Section 1, the Commission just announced a complaint to Altria's investment in Juul last week. And we did plead a Section 1 count there. And so I think that should be interesting reading for folks who are thinking about the use of Section 1 with respect to a merger. With respect to Section 2, I'm going to approach it from a slightly different angle. I'm going to talk about when Section 2 should be alleged in addition to Section 7 in the face of a merger that one of the agencies is interested in challenging. Obviously, one important consideration is the elements of each claim. So we've talked about Section 7. For Section 2, we need to demonstrate monopoly power and conduct that maintains that monopoly. And the Commission actually has challenged acquisitions using Section 2, as we've talked about a couple of times already in Illumina PacBio. The Commission challenged the acquisition under both Section 7 and Section 2. And as folks have been discussing, the Section 2 claim allowed the Commission to show that Illumina had a pattern of acquiring nascent competitors. I, in particular, thought it was very important to have that pattern evidence in the complaint. But more than a decade ago, in 2008, the Commission charged Inverness Medical Innovations, the leading maker of popular consumer pregnancy tests, with seeking to maintain its 70% market share by acquiring the assets of a smaller competitor that was developing a new consumer pregnancy test. And to settle those charges, Inverness agreed to divest the assets and also agreed not to interfere with a joint venture to develop competing digital consumer pregnancy test products. And so this goes back to what I was saying at the beginning. The Commission and the Department of Justice have a history of challenging acquisitions involving nascent competitors and potential competitors, and we will continue to bring cases on that basis.
Thank you very much, Commissioner Wilson. Moving to non-price effects and values a little bit, Carl or Dr. Shapiro, how should we measure potential benefits and harms in zero price and multi-sided markets when technology companies merge? What metrics can and should we use, and how do we identify and qualify those impacts when it's a non-price or zero price in a multi-sided market?
Well, first, let us be clear for all who care to listen that antitrust is not only concerned about price. Those who say so are either poorly informed or have some nefarious agenda. But we do focus a lot on price. Why is that? I think it's for two reasons. One, it's amenable to measurement, right? You can tell whether the price is high. You can talk about whether it went up or down. You know, you can measure consumer harm using prices. So it's simply a data measurement issue. And also related, it is built into the hypothetical monopolist test that we use for market definition. So price has a special place. And of course, you then turn to economists like me and say, oh, you guys do numbers, so talk about price. But it really is not. Let's put it this way. We've also talked a lot about innovation, and that is fundamentally not about price. It's about improvements in product quality. We also concerned about variety, that people have different choices, right? Okay, so price is not the all and end all. You specifically asked about situations where multi-sided and where the price is zero, though. So, let's give an example. Let's say, Google has, they have their search services free, but of course they get advertising revenue that's their bulk of revenue. Okay. So that would be one example. Facebook is also free. These social media platforms are a very good example of free services where they get money from the other side. So first off, this area is now, we got huge problems involving these multi-sided markets because of the Supreme Court's decision in the American Express case. It's a horrendous decision, both in terms of the economics is terribly argued. It's confusing. People should read Breyer's dissent along with Thomas's decision because Breyer eviscerates it. So, but we have that. That's out there. The fact that I don't like it and that I think almost any scholar will tell you it's very low quality logic, we have that. So, which is telling us, suggesting to the courts, gee, you better not just look at one side. You've got to look at all these things together and how you define markets. So I think that is going to be very problematic. And I think there's a role for the agencies to try to dig us out from that if the agencies are actually interested in enforcing antitrust law in this area where we have two-sided markets. Now, in some cases, we can still measure price on the other side. So my examples, we can measure price to advertisers, right? You could have an acquisition, and maybe you go back and think about Google, YouTube. It's a long time ago. Would they have been competing for advertisers? And would that have made a difference in the price of advertising, even if it didn't affect the price of that it's a free service to users? We also could try to measure quality effects, right? I mean, we could measure the value or try to measure the value to consumers of improved quality. There's ways of doing that with surveys or with other market data. So there's things we can quantify besides using price. But I think the deeper problem created by American Express decision is the suggestion that one needs to look at all these sides of the market before you can even move off for market definition, before you can get anywhere. In my view, the correct approach is to look at one side, see if there's effects there, and then see whether the other side, there's enough action there or countervailing to change the result. Normally, that won't be. That would be an unusual circumstance. But we do have the Supreme Court case to deal with on that.
Thank you, Carla. Just moving to a different non-price effect, how should we think about and measure potential privacy effects in technology merger when individuals value privacy very differently? Diana, do you have thoughts on that?
Sure. Thanks very much for that question. So I agree 100% with Carl. Obviously, we look at price and non-price effects in antitrust analysis. Non-price effects largely include quality issues, innovation issues, and as part of quality, certainly privacy could be considered a non-price quality effect. So the question for enforcers is, how do mergers and acquisitions change the ability or the incentive to compete on quality, and more specifically on keeping user data safe and secure? So to answer that question, I think we have to go back to first principles and remind ourselves that these ecosystems, whether they be digital market ecosystems or other types of ecosystems in agricultural biotech or the medical supplies and equipment area, really are fueled by the use of data and the transference and enrichment of data through, say, artificial intelligence and machine learning. The connectivity is fueled by the use and enrichment of that data. And so that's what keeps these ecosystems kind of humming along and hanging together, and raises concerns about, pro-competitive or anti-competitive incentives. So I think we have to ask ourselves as economists, or I do, that how does privacy relate to sort of basic models of competition? Do firms have stronger incentives to maintain privacy regardless of whether they're large dominant firms or smaller competing firms, given how important data is and the leveraging of data and the shepherding and the stewardship of data? it may not be clear that having more competing firms provide stronger incentives to protect consumer data. I don't think that question has been resolved. And so then we get to the problem, of course, which is, well, if it is to be measured, privacy is to be measured as a non-price dimension of competition, how do you do that? When different sets of users have different preferences about privacy. I value my privacy tremendously. I'm not on social media. I minimize my presence on the internet. But that's a generational issue for me. My kids appear to be less concerned about their privacy. So how does economics and antitrust analysis sort of deal with that in the context of putting a value on privacy, giving different user groups? That's not a whole lot different than how we look at price effects, in terms of establishing the marginal benefits and the marginal cost of some sort of social optimum. And finally, I'll just note that I think antitrust enforcement is really getting up quickly on the learning curve, but we haven't really seen the non-price quality privacy dimension really fully explored. I would point to the Facebook WhatsApp acquisition that the FTC looked at. They produced some really good transparency and guidance on that, but it was a letter from the Bureau of Consumer Protection to the parties in that case that said, hey guys, we want to make sure that post-merger WhatsApp really sticks to its privacy obligations and its privacy policies. That letter didn't come from the Bureau of Competition. It came from the Bureau of Consumer Protection. And we need to see a melding or a nexus between those two sides, in the agency. The FTC is ideally positioned to do that, given their expertise in those two areas.
Thank you, Diana. The FTC definitely has expertise in both of those areas. Talking about a different area of non-price effects, which, and we've talked a little bit about this before, is innovation. Mergers can spur greater innovation, particularly when the acquirer has the resources to further develop innovation, an innovation that the target may not. Additionally, innovation may be spurred by the hope of small company founders that the market will reward their efforts to innovate through a larger company investing in them or acquiring them, keeping the market liquid. At the same time, we risk losing the innovation of smaller companies if they are bought and squelched, or the trajectory of the innovation is diminished by the acquisition. How should we balance the potential pro-competitive benefits and anti-competitive harms of innovation in this area? I'm going to probably keep this a little bit shorter because we're running a little long on time. Foad, do you have thoughts on this?
Sure. And I think the balancing exercise is particularly delicate for the European Union and the European Commission for two reasons. One is that obviously the European Union is not such a big hub for startups as the US and the West Coast has been. So European Union will be very careful adopting any kind of enforcement policy which might lead to reduced incentives for startup or innovation. And I'm saying that because, of course, in this debate, there are those that are claiming and arguing and having data supporting that many startups and innovation is driven by the fact that they can be acquired, that there is an exit strategy, and that if we kind of lower the thresholds for intervention, maybe we ultimately in the long term are reducing innovation and actually are not, which is not benefiting the consumer. So European Union is, of course, will probably not take such a move if there's a risk that will further reduce the incentives for innovation within Europe. The second point that's delicate for the European Union is that the European Commission, as a supranational authority, has worked very hard to gain credibility and acknowledgement within the member states and beyond. And that has been done on the basis that their decisions are always reasoned. They have to be reasoned, they have to be detailed, enabling parties to challenge them. And over the 30 years of enforcement, I think it's fair to say that European Commission's, particularly its merger decisions, whether you agree with them or not, they have established themselves as a serious enforcer, that they have a framework that people at least can follow their reasoning. Now, if in the challenges of digitization, the procedure burdens of European Commission be lowered, I think that would lead to reduce legitimacy and in the long term reduce trust in the enforcer. which ultimately, again, will probably not be a good thing because having the business community not having a trust in the enforcer will also not be good for the business and the business environment overall. So I think the way the European Commission will balance this is, again, to try to be very transparent about which framework they will use. We will see at the future market definition notice and also any kind of guidance paper they will issue. I think they will define a quite clear framework how they will approach these cases without necessarily try to change the procedural laws or the burden of proof that they have to bring.
Okay, thank you, Foad. Diana, do you have a few thoughts on this briefly? And then Commissioner Wilson, we want you to hear your thoughts on this as well.
Sure. Just a couple of thoughts on sort of the models of innovation that are endemic to the digital ecosystems, or any ecosystem for that matter. I'm personally not a big fan of antitrust standing down for anything, especially a reason or a rationale motivated by protecting, this VC, CVC kind of business model. The economic evidence is really clear. Competition drives innovation. Absolutely. You need competition to drive innovation. And there have been many different models of innovation in economic history teaches us over many decades. Those are diverse models. There's parallel path innovation and branded drugs. There are other models of innovation, and they all drive competition, or competition drives them in a pretty integrated feedback loop. So I think we have to really consider that, and why antitrust has really chosen to forbear from enforcement in this particular space. But I think the evidence is now showing that those were perhaps not well-motivated decisions. So I would just sort of leave it at that, and note finally that the high failure rate on mergers, it's up around 70%, really is not supportive of any sort of policy decision making that would suggest standing down from enforcement in these ecosystem types of cases out of the risk of imperiling a specific innovation model.
Commissioner Wilson, do you have a response on that, or some thoughts just more generally?
Yeah, thank you, Heidi. So I think, a lot has been written in the economic literature about where innovation comes from. And we have the whole Arrow versus Schumpeter debate. And so I think it's actually a pretty complex discussion, and one that certainly would take far too long to address here. But the fact is that in some instances, larger firms are better situated to expand on innovation. And so I think in the abstract, it is really difficult to establish an ex-ante policy that balances these possible market effects. In December, the OECD had a roundtable on establishing barriers to exit. And as I described then, I think it would be very imprudent to create bright line rules that make it much more difficult or impossible for small firms or startups to sell themselves to more established firms. Now, to be clear, there may be good reasons to block the acquisition of a nascent competitor by a firm with significant market power, but the inquiry is necessarily fact-specific and predictive in nature. Specifically, it seeks to predict whether this startup would end up being a significant competitor to this acquirer in this market in the near term. And so I think there are at least three reasons that we need to be really careful about establishing bright line rules for acquisitions of nascent competitors. First, a blanket rule would dispense with the foundational requirement that we conduct a factual and case-by-case assessment. This approach would be an extremely blunt instrument that's also likely to prohibit potentially pro-competitive transactions. Second, I think a blanket rule would reduce innovation by large firms by prohibiting them from acquiring new ideas and new technologies that they can then build out on their vast platforms and take advantage of the economies of scope and scale that Carl described at the beginning. And third, a blanket rule may reduce innovation by startups by reducing their expected profits and depriving them of earnings they can reinvest in their next project. So depriving innovators of what you might call exit capital realized by selling their business to the highest bidder, is particularly problematic in industries like high tech, populated by serial entrepreneurs who rely on that capital to start their next venture. And this is not just a theoretical conversation. Let's consider the case of Elon Musk. He is the founder and current CEO of Tesla. He got his start by founding a software company called Zip2 in 1995. He sold that company 4 years later to a computer company called Compaq and used more than half of his proceeds to found an online banking company called X.com. We know that as PayPal. That's what it became in 2000. When PayPal was acquired by eBay in 2002 for $1.5 billion, Mr. Musk put his share of the proceeds toward founding the aerospace company SpaceX in 2002, investing in a startup called Tesla in 2004, and investing in another startup called Solar City in 2006. And those firms all continue to grow today. And without that startup capital, those companies would not have been possible. And Mr. Musk is not alone. The serial entrepreneur is fairly common, particularly in the tech industry. Two other co-founders of PayPal, Peter Thiel and Reid Hoffman, used their proceeds from that sale to fund investments in startups called YouTube, LinkedIn, and Uber, which of course we all know today. And so I think we need to tread very carefully when we're talking about creating a blanket rule that would create barriers to exit for startups.
Thank you, Commissioner Wilson, for those thoughtful comments. Moving to sort of issues that everyone has touched on in the discussion today, do we need new antitrust merger laws or guidelines specifically for technology companies or a technology regulator? Should we have separate or different laws or merger guidelines, including new or different presumptions and or different filing thresholds, or a separate technology regulator for transactions involving technology companies? If yes, what would that look like? And would it apply to only a subset of large technology companies or more broadly? Carl, you've had a large role in guidelines throughout your career. Can you give us some thoughts on that?
Well, thank you for that. Of course, the current merger guidelines released in 2010 are so excellent, it's hard to see why you need anything else, since they cover all industries perfectly. More seriously, I am generally skeptical of sector-specific guidelines regarding mergers. I mean, there's nothing wrong with having healthcare guidelines about some particular, regulatory structure or banking. Okay, so there are areas where there are a set of rules and the agencies are trying to work with the FTC or DOJ work with other agencies. The banking is probably the best example of that, where the DOJ is working with the Fed. But I think, those of us who do mergers, everybody here, right? We realize the fact-specific. Each industry has its own factors, and you need. That's true of tech, but it's true of you could say that about pharmaceutical. You could say that about transportation, on and on. So I think the way to deal with that is for people to give speeches, and have other statements, and of course when they actually do cases, we learn a lot from that. So those guidance, and that's developing over time. And Commissioner Wilson has pointed out a number of those on this conversation today. So I don't think we need new guidelines. On the other hand, in the tech area, I think we're badly overdue for new regulations. And this would be laws now, moving from guidelines to laws. We desperately need raw laws that are going to help us with privacy issues. What I think is generally called information disorder, which the duties of platforms, cybersecurity. There's just so many, and Congress is not moving on this, and I don't know when they will. Obviously, with the current crisis, everything's going to be slower. That's not related to the crisis. But when we have those if those laws get put in place and regulations in place, the FTC is obviously one natural place to look to handle that. Then you will have defined companies that are subject to those regulations, just like we have common carriers in telecom. There will be something called a dominant platform. If you look at the proposals out there, the report prepared for Commissioner Vestager, the UK CMA report, the Stigler Center report with Fiona Scott-Morton as the lead author, they all have a notion of some companies will be subject to these, will be defined as dominant platforms or something like that. And then you can have, then the agencies can work with that regulatory structure. And the law could say, if you're defined in that category as a company, then we're going to be stricter about mergers or acquisitions. That would make a lot of sense.
Okay, thank you, Carl. Commissioner Wilson, do you have some thoughts on sort of new guidelines or new laws?
I do. So first of all, I would say that I agree with Carl that it would be incredibly helpful to get federal privacy legislation that in part addresses the accountability of companies with respect to data that they gather and analyze and monetize and share. And I do believe actually that this would go a long way toward clearing up some of the concerns about what we characterize as big tech. So Diana mentioned that there is an incentive to grow, and there is an incentive to put privacy to the side as an aspect of non-price competition because of the economies of scope and scale with data. But if federal privacy legislation places some boundaries on the information that can be collected and how it can be used, I think that that would actually start addressing some of the concerns that we have in this area. That said, I think setting privacy legislation aside, we should be wary of proposals to create sectoral regulations that go beyond the traditional bounds of antitrust. And we don't have to look very far to find examples of why this is the case. And so failings of comprehensive regulation in the U.S. transportation industry provide a great cautionary tale. First example is the Interstate Commerce Commission. It was created to regulate railroads for the benefit of shippers, but it ended up stifling innovation by the railroads and protecting inefficient rivals like barges. And this is a great example of anointing certain companies as subject to regulation and then having that area of regulation expand. Initially, the regulations covered railroads, and lo and behold, it turns out that trucking competed with railroads, and so the ICC got jurisdiction over trucking, and then the same for barges. And when the railroads wanted to implement new technology that would lower their prices, they were told by the ICC they couldn't lower their prices to the extent they wanted because it would harm inefficient rivals like barges. And similarly, the Civil Aeronautics Board was created to regulate airlines for the benefit of passengers. But the CAB ended up blocking airline entry on routes and maintaining artificially high prices through artificially low load factors that were used to establish rates. And when the CAB was disbanded, it was a tremendous boon for consumers. Output increased significantly, and flying became a routine experience for people of all walks of life. And so the point is that regulation is rarely as simple and beneficial as people hope. And second, to go back to a point that Carl started with, it can be very difficult to define technology companies. Consider the companies involved in the cases that Haidee identified at the outset of the discussion. They're not GAFA companies, but I would submit they could well be considered technology companies. So in Illumina PacBio, it was the technology for DNA sequencing. In CDK Automate, it was platform business software used by U.S. franchise automotive dealers. And in DOJ's Sabre Farelogix case, it's booking services for airline tickets. And then just to close the loop on a couple of topics that we've discussed, the Commission is grappling with these issues through a 6B study that's designed to investigate prior acquisitions by technology platform companies. But as I said, when the 6B study was announced, I believe some of the issues alleged for platform technology companies likely arise in other industries like pharma, dialysis, and hospital markets. And so for all of these reasons, I think there's no reason to treat digital platforms differently from other markets.
Thank you, Commissioner Wilson. Diana, do you have a few thoughts on different laws or merger guidelines?
I do. Thank you. So antitrust is law enforcement, and it's a generalist form of law enforcement. And because of that, carving out special rules for particular sectors or special treatment for particular sectors really would be highly unadvisable for a lot of really important reasons. It would potentially create conflicts in how the laws are interpreted across sectors, for example. would very likely cause confusion in the courts, and we struggle already with the courts in terms of antitrust decision making and analysis and outcomes. And so I think the balkanization of antitrust to treat different sectors with special rules would really potentially weaken antitrust even further. That said, I think the right approach is to strengthen and clarify the existing antitrust laws. And we do have legislative efforts that do that. For example, Senator Klobuchar's bills, more sort of comprehensive forms of legislative action that is designed to strengthen and to clarify. We need stronger presumptions. We don't just need presumptions for horizontal mergers. We need them for vertical mergers and potential competition mergers, much like I noted earlier. And then I would just note that what's going on in the digital markets, but also in other markets that are ecosystem type markets like ag, biotech, and the other examples I've given. These are public policy problems. They raise a real host of issues, competition issues. They raise issues surrounding privacy. Just a whole host of factors that we're grappling with as part of fundamental changes. So if it's a public policy problem, we need a public policy solution. Antitrust is one tool in the toolkit for sure, but there are other tools. So for example, regulation is another powerful tool, and we see that in other sectors with sector regulators working in a complementary fashion with antitrust. If that's considered for the digital technology sector, it should be done under that umbrella. So regulation potentially to address privacy problems, systemic privacy problems, any sort of regulation to address non-discriminatory access and interoperability standards. But that is separate and apart from antitrust, but should be structured to work in concert with antitrust, much like we see in other sectors. So retain generalist antitrust laws, strengthen them, reinforce them, bring them more up to date, but also have other tools in the toolkit that can work to bootstrap antitrust and to strengthen the whole approach.
Thank you, Diana. Foad, do you have a few remarks on this? And then we're actually very close to the end, but I think it's important to hear your perspective on this. And then I have one more question for Commissioner Wilson.
Sure. Thanks, Heidi. Very, very quickly, I think on this point, we all agree, it seems, on the panel, and I do think so as well, that don't see any benefit of having antitrust-specific regulation for specific sectors. What I think is, though, important, again, putting the European hat on, is predictability and avoiding as much as possible the perception that the enforcer, European Commission, could act in an arbitrary way. So by having, in one shape or another, a sort of framework communicating that, the analytical framework that they intend to follow when addressing tech mergers, for instance, I think that is very helpful because it will, again, maintain their credibility. It will also prepare the parties for what is expected from them in terms of the information they need to provide and how to assess any kind of transactional risk or competitive concerns. And there, I think European Commission is doing a quite decent job. I mean, they will work on a new market definition notice. That will be helpful. But they're also quite often now, through these reports and conference and speeches, as Carl was mentioning, giving some sort of guidance to the business community and private practice, just as they did when they were looking at agrochemical mergers I mentioned before, where they came up with this novel theory of harm. They were quite quick and keen on getting out there in a lot of conferences with a lot of articles to explain how they were looking at this new theory of harm of innovation competition.
Thank you, Foad. And we'd be remiss on this discussion if we didn't talk about the FTC 6B study. Commissioner Wilson, what is the FTC 6B study and what is it covering and what should we expect from it and when?
So in mid-February, the special orders were issued to 5 large tech companies, requiring them to provide information about prior acquisitions not reported to the antitrust agencies under the Hart-Scott-Rodino Act. The orders require Alphabet Inc., including Google, Amazon, Apple, Facebook, and Microsoft to provide information and documents on the terms, scope, structure, and purpose of transactions that each company consummated between January 1st, 2010 and December 31st, 2019. And of course, this is prompted by a great deal of concern about mergers that the agencies may have missed in the past. In the tech space, we've heard Diana talk a fair amount about that. You've also heard Chairman Simons and me talk about the need for retrospectives from the time that we were nominated, and definitely during the confirmation process. And so it is a topic that is of great importance and of great interest, and I am very pleased that the agency has undertaken this initiative. So the special orders require the companies to provide a host of information. Topics include information similar to that requested on the HSR notification and report form, materials on the respondents' corporate acquisition strategies, voting and board appointment agreements, and agreements to hire key personnel from other companies, and information related to post-acquisition product development and pricing, including whether and how acquired assets were integrated and how acquired data has been treated. So the Commission plans to use the information obtained in this study to examine trends in acquisitions and the structure of deals, including whether acquisitions not subject to HSR notification might have raised competitive concerns. The Commission also seeks to learn more about how small firms perform after they are acquired by large technology firms. These and related issues were discussed extensively during several sessions of the FTC's 2018 hearings on competition and consumer protection in the 21st century, and this study is part of the follow-up from those hearings. The Commission has already started to receive materials from the companies that received the special orders, and I look forward to sharing the results of this initiative with the bar and the public soon. If you heard a cat sneezing in the background, I would be happy to restate some of that if that would be useful for recording purposes.
That was great. Thank you very much, Commissioner Wilson. So we are at the end of this very interesting discussion. Thank you very much, FTC Commissioner Christine Wilson, Dr. Carl Shapiro, Diana Moss, President of the American Antitrust Institute. Thank you very much, Foad HOSEINIAN, who is with Sullivan and Cromwell in Brussels. Thank you. John, back to you.
Thanks, Heidi. Mike, Joanna, very interesting panel, and I'd like to get your take. Mike, let's start with you. What's one takeaway you had from today's panel?
Well, it was a great panel. I was really proud of how the panelists navigated doing a spring meeting panel by podcast. And I really took away that there seems to be a pretty strong consensus among all the panelists, despite their different viewpoints, that having sectoral specific guidelines is probably not the way to go. So I thought that was really interesting.
Jonah, what about you? What's your takeaway?
My takeaway is that predicting the future is difficult, and even more uncertainty with emerging companies. So issues such as measurement of shares, diversions that we typically encounter in any and all merger analysis are even more difficult with assessing the effect of an acquisition of a nascent competitor or emerging company. I think we've learned that we need to rely on the best information available from the parties. The fact that it's difficult doesn't mean we can't do anything about it. And the best information, sometimes that comes from documents that discuss prospects from the parties. And in these situations, it's even more important to adhere to basic principles. What is the likely effect on competition of this acquirer's acquisition of this emerging firm in this particular commerce?
Mike, back to you. Another takeaway?
Yeah, I thought that the discussion between Commissioner Wilson and Dr. Shapiro and Diana Moss was really enlightening around how to manage our way through these tricky questions. And there's different parts of the toolkit that might be available and called for by different people. And Diana really pushing hard for new laws and regulations. And I think, Dr. Shapiro being, open to theories of harm that are a little bit harder to prove, and a real push by Commissioner Wilson to keep things based in real specific data and proof of theories of harm, and not wanting to veer into regulation. And I particularly enjoyed her discussion of barges.
Gianna, how about you? Do you have another takeaway for us?
Yeah, another takeaway I have is that Commissioner Wilson reminded us that, as in the merger analysis of any other sectors, it is important to evaluate the potential harm and potential benefits of a merger in a symmetrical way. In tech, the potential benefits also include dynamic effects on innovation. And I thought that was really important to be mindful of because we are, dealing with the digital economy and technology, and innovation is part of, what makes this economy grow.
Mike and Joanna, thank you. Mike, I want to come back to you and ask you, what is the Merger and Acquisition Committee up to, and what are some ways that people can get involved?
So thanks. The M&A Committee continues to be very active and be very creative, and thanks for your partnership at the Curious Amalgam as part of that work. We do have upcoming programs that will be rolling out, phone programs, and we'll be pushing out content to our membership about that. And of course, stay tuned to our quarterly newsletter, The Threshold, which always contains very, very interesting and timely content.
Joanna, you're an economist. Is Merger and Acquisition Committee a good committee for economists to be involved in? There are things for economists to do?
Absolutely. As you know, and as we all know, that there are a lot of relevant economics within the analysis of mergers. And, I'm an economist. I'm on the committee as a co-chair with Mike. We also have another economist, a white young economist rep, Paul Wong, on our committee. And in fact, let me just, use this opportunity to give a shout out to our committee's leadership for all of their excellent work this year on our committee. Haidee SCHWARTZ, the moderator for the program that we just heard, Kavita Pillai, Carla Hine, January Kim, Megan Griffith, Michael Gleason, Scott Shealy, Paul Wong, Lucy Chambers, and Jamie Sadler. If you'd like to get involved on our committee, feel free to reach out to any of us, and we would be happy to get you involved.
Well, great. Well, that's all the time we have. Thank you, Mike and Joanna, as always, for your great commentary. I also want to thank the panelists, Haidee SCHWARTZ in particular, for a really interesting program. And especially I want to thank our members who are joining us. Everyone, please be safe, please be well, and we will see you next time.
Thank you for listening to this 2020 Virtual Spring Meeting edition of Our Curious Amalgam. It is produced and shared around the globe by the American Bar Association Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard and would like to become a member of the ABA Antitrust Law Section, visit us at ambar.org/antitrust to learn more. If you have feedback for the podcast or are interested in participating in a future episode, please reach out at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.